say that's as much Dutch as you will hear today. Let's switch over to English now, because I'd like to introduce our long-standing partner and friend and today's speaker to you, Mr. Thomas Torelli. And Thomas Torelli is from the legal firm Torelli and Associates in Chicago. I think maybe half of the people listening today probably already know you, Tom. But if I had to introduce Tom, I mean, I wouldn't actually know where to start. Tom, we know each other for over 20 years, I think. And you have, in all those years, you have probably helped hundreds of our members in doing business, minimizing risks in the USA. And you have also built up a lot of knowledge, experience about our sector, and especially also, you know, a lot about the small and medium-sized companies. Tom, I would say maybe it is better if you introduce yourself, and that you will also, after that, immediately start with your presentation, which is about product liability and prevention, terms and conditions on sales, intellectual property, and the legal aspects when installing and working in the US. Is that about correct, Tom?
That sounds good. We'll try to touch as many of these subjects as we can. And those questions that you may have that you don't get answers to today, I'm always available, as I have been since I started working with Metaalunie, for a 1-hour meeting via Zoom or Teams, or potentially in Nieuwegein at some point in the future, maybe March, April, or May, when Paul and I get around with Birgit to set up a visit to your wonderful offices. Torelli and Associates, I'll tell you a little bit about us, and in that context, you'll get an idea of what it is we do and what it is that we think is important for you to consider when you're doing business in the US. So we're 5 lawyers. We're located here in Chicago, and we work exclusively with small to medium-sized European companies doing business in the United States, trying to help them take advanced preventive action to minimize their exposure to legal risk when doing business here. That's the best way. It's the cheapest way to use lawyers in the United States. And it's the way we Americans use lawyers in the United States. It's really important for you to understand that just because you don't talk to your lawyers when you do business in Germany or France, well, you better when you do business in France. I lived in Paris for 9 years, and our daughter thinks she's French. So I may say things about France that may not sound flattering, but I love France. You may not talk to your lawyer when you do business in neighboring countries, but when you do business in the United States, you need to talk to a lawyer. Why? Because Americans use lawyers all the time. And if you think about it, you realize, oh, if they're using lawyers all the time, why would they do that? Well, because Americans view the law as an important part of doing business. Now, why would they do that? Well, because they think that legal rights and legal assets can enhance the value of their business. For example, if I'm an American partner and I can get you to sign a contract that gives me exclusivity for 10 years without any minimum sales, if there are any problems, they're yours. You get the insurance that covers us both. Any enhancements or developments that I make, I own, et cetera, et cetera. Well, for goodness sakes, it's in my interest to get such a contract because it adds value to my business. I could maybe sell that contract to a competitor of yours that all of a sudden has exclusive rights to your products and technology for 10 years. That's not the way Americans operate in terms of selling rights to third parties or anything like that. But we understand that enhancing the value of our business is well worthwhile. So what do? Most of our clients distinguish themselves with technology in some form. Either they do it, they have better features, they're safer, they're faster, they're more effective somehow, etc. And as a result, that technology is what helps distinguish them from their competitors in the market. And that technology needs to be protected, whether it be copyrights, trademarks, patents, confidential information. I'm a nut when it comes to trademarks. Those of you that have trademarks that are not yet registered anywhere, please let us have a conversation about the importance and value of trademarks. Those of you that have a vision or a commitment to doing business long-term in the United States, please consider protecting your intellectual property rights as soon as possible. We'll get into that in a little bit in more detail. The second area that we work in is in contracts, whether it be a sales agreement, distribution, license, sales terms and conditions, adapting Metaalunie's terms and conditions to the US market, for example. We'll talk a little bit about that later on as well. Limited warranties. Guarantees. Never use the term guarantee in the United States because that means that it's a full lifetime guarantee. Even though you may have limitations underneath it, always call whatever you're promising a limited warranty because that's crucial in the United States because we have a very strict warranty law in the US. So all kinds of contracts. Setting up companies. Some of you may already have companies in the United States. Congratulations. Others, why would we set up a US company? We'll talk a little bit about that. But there are lots of reasons for those of you that may be committed to doing business long-term in the United States. It makes a big difference having a US company in place. The fourth area is immigration, and we'll talk a little bit about that too. The grand scheme of things is if you are committed to doing business in the US and you decide to send people to live and work in the United States, that requires a lot of advanced planning, a lot of thought, setting up a company, hiring people, hopefully leasing an office, and running your US business through your US company. I suspect that that is not the primary purpose of your interest in immigration today. You want to send people to the United States to install equipment, provide service, maintenance, training, et cetera, et cetera. We'll get into that as well. And that is not an easy thing. So again, because Americans, and we also offer this service called product liability preventive management, which we're also going to talk about a little bit here this afternoon. And then clients do get into fights. And so indeed, we have a couple of Dutch clients that are in lawsuits here in the United States. And our job, however, as we view it, is to try to help you minimize the risk of ever getting into a lawsuit, because you don't ever want to be involved in lawsuits in the United States because they're extraordinarily expensive. But more than that, they're very time consuming. The amount of work that you would have to do, including paying your lawyer, is crazy. So you want to avoid that to the greatest extent possible. So to summarize again, intellectual property, contracts, all things having to do with setting up companies, immigration, product liability, and dispute resolution. Those are the areas that we work with, and about 98% of our clients use us for all of their legal needs in the United States. So,
Tom, do you, just to interrupt, do you want me to start the presentation, or do you have the presentation yourself and you want to go through it?
I'm not smart enough. I'm not smart enough to be able to manage that, Paul.
Can I try to get it on the screen? But
yes,
you'll probably have to tell me when to go to the next page, but we'll sort that out.
That's fine. And then we get to see your wonderful logo. So the first area is intellectual property. Now, you might say, yeah, but we're just selling a machine. And for some of you, let's skip all the way to intellectual property, Paul.
This one?
No, it's called intellectual property.
Okay, great.
So I could remember it. Some of you, those of you that are doing business in the US opportunistically, namely, we have plenty of business here in Europe and we're more interested in China or whatever, but every now and then you get an order from the United States. Well, that's fine. There's, there are lots of things, and please stay on this webinar, because there'll be lots of things for you to think about when you do business in the US. But protecting your trademarks in the US may or may not be very interesting for you. However, for those of you that have more than just an interest in doing business whenever an order comes in the United States, our view is either you protect your intellectual property rights now, or you're risking not being able to protect them at some point in the future. So I look forward to speaking with you about this, those of you that want to take advantage of the 1 hour of free time to discuss your particular situation. What I'm talking about now is very, very general and may not apply to many of you as you move forward with your business in the US. That's why I offer this hour to go through what it is your plans are, the special circumstances, your competitive position, etc. What you know about your American partner. Before we get further on this intellectual property thing, we Americans are very enthusiastic. We're excitable. Yes, we can. We're optimistic. We're positive and all that kind of stuff. But does that mean that we're really interested? No, it doesn't mean that we're really interested. The only way you can really tell whether somebody's interested is to be demanding. Be demanding of your American partners, especially partners, maybe not customers so much, but partners, agents, distributors, potential licensees, joint venture partners, etc. Be demanding of them, then you'll find out whether they're really interested. We prepare distribution agreements all the time, and one of the provisions of our distribution agreement says, attached here too as Exhibit 3.1 is the distributor's marketing plan for the first year of the distribution agreement. And sometimes when we send that to our client, the client comes back to us and says, hey, Tom, I see that Section 3.1 refers to a marketing plan. Has the distributor sent you a marketing plan? No, they haven't sent me one, and that means they haven't sent you one either. You may think this sounds so obvious that it's silly, but it's not silly. Why? Because so many Europeans, and our clients are almost all European, so many of our clients view the United States as being a long way away. It's gigantic. It's got an enormous population. It's not one market, it's lots of different markets. Americans are litigious. Better just let my partner in the United States take over all responsibility, and I'll keep worrying about my European market and expanding into China, India, or wherever. I know I'm talking to some of you people. I know I am, because it happens all the time with us. I'm on the phone like this, not giving speeches like this so much, but every day. I'm on the phone with companies, and many of them are looking at the US kind of like, yeah, I guess I'm going in kicking and screaming into the United States. No, you don't go in kicking and screaming. It's better to put a big X over the United States than it is to sort of hope that things work out in the United States. That's a great way to waste money and time and risk your business in Europe, is to look at the US kind of like, well, we'll take care of it as we go along type of thing. Like, oh, well, we've got a budget of 200,000 euros that we're going to allocate to the US. And after we've spent that 200,000 bucks or euros, then we'll take a step back and see where we are and decide whether we go on or not. No, better save that 200,000. Invest it somewhere else where you're committed. Don't do business in the US to play. Do business in the US to win. It's an entirely different perspective. You've got to have a long-term view to being successful in the US. Yeah, but we just have a piece of equipment. Now let's get back to selling our piece of equipment, installing it, and getting our people over to the US. Yeah. We are. But again, just by shipping over a piece of equipment to the United States, all of a sudden you're exposed. You're exposed in the United States. Some of you are maybe selling equipment to people in the United States. You're really not sure what they're going to use it for. Ooh, that's a mistake. Why? Because we're going to get paid for it, so we don't care. Yeah, you do. Why? Product liability. If you don't know what your client's going to use it for, and they use it, and it breaks down and somebody gets hurt because they're not using it properly. Okay, let's understand one thing from the get-go about doing business in the United States. Product liability is a problem, and it's going to be a problem for those of you that are ultimately subject to claims from the US. Why? Because the person that gets injured is not the person that you have a contract with. You follow me? You have a contract with your customer, you have a contract with your distributor, your agent, your partner, whoever it might be, that puts the responsibility on them, hopefully, to resolve any claims that might relate to the use of your equipment. Well, that sounds great, doesn't it? And that should help. It certainly will help. But the person on the shop floor that uses the equipment, you didn't sign a contract with them. You signed a contract with their boss, their employer. That person that gets injured has rights, and has rights against their employer and against the manufacturer of the machine, the shipper of the machine, the installer of the machine, the servicer of the machine, lots and lots of people, lots of companies, and you're one of them. So for those of you that are scared to death of product liability, and that was the case when I started my firm years ago, it's a long time ago, there were people that said, we're not doing business in the United States because we're afraid of the litigation culture, the lawsuit culture of the United States. I think most of you now realize that that's a risk of doing business. That's a cost of doing business in the United States. But there are things that can be done and need to be done before you start selling to the United States that'll reduce your exposure to legal risk. We're going to get into that here in a little bit. But so, those of you that have a commitment to doing business in the United States long-term, please make sure that you register your trademarks and copyrights. If you have patents, they should be protected as well. I'd be delighted to talk with you about that.
Shall I go to the next page?
Yeah, the last thing on this page is licensing of software. Now, this is a primer for many of you, because most of you that sell equipment also have software associated with the running of that equipment. And we have seen clients, even today, selling their equipment and along with it, their software. Here's the equipment with the software. It's yours. And the client thinks, the company thinks that, yeah, but we've got a toggle switch that we can turn off anytime if they don't pay us our license fee or blah, 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 whatever and whatnot. And you may have that covered in a contract, maybe not, usually not, which can get you into trouble. But the big thing is that if you've sold the equipment and the software with it, without specific language that states that you're licensing the software, guess who owns the software? You own it, and so does your customer. Yeah, sure, they can own it, but they don't have the source code, so it's of no use to them. Well, we've been involved in disputes where customers in the United States that have bought equipment with software have insisted on receiving the source code. You don't want to get into a fight with that and in a lawsuit about that when all you got to do is to say, we're licensing the software. And I know I'm talking to a handful of you. about this. This is crucial. Doing business anywhere, not just in the United States, but doing any business anywhere. Namely, if you've got any software that's involved in your equipment, make sure that you're licensing that software to customers and not selling it along with your equipment. You don't want to get into fights in the US. Let's go into the next page. Is this the contracts? Okay, this relates, I think, to sales terms, and no, that'll be the next one. All right, so we'll get into the sales terms in a moment. This issue about contracts is relatively straightforward. When you do business with partners in the United States, especially customers, you'll try to use your sales terms or a sales contract. You know, depending on whether you're selling a commodity, which most of you are not, otherwise you'd probably not be doing business in the US. But if you're selling commodities, then, you know, sales contracts may or may not be all that important. When you're selling specialty equipment, then having a sales agreement to me makes a lot of sense. And why is that? Because you want to get into detail what the purpose is of the equipment or the product that you're selling, so that it's very limited. You follow me? Namely, it's not a very broad description of your equipment, but what is the specific purpose of the equipment? Remember, I spoke a few minutes ago about not knowing exactly what your customer is going to be using the equipment for, and the risk that that exposes you to product liability claims later on. In fact, it would not be a good thing to not know what the purpose is for the use of your equipment, because it would be a sign that you did not act particularly responsibly when you sold the equipment in the first place. You understand that? That's an important one. It's really important to understand what your customer is going to do with your equipment. And, you know, usually you do, but in the US, it's really important because of this product liability issue. So in the contracts, and my recommendation is that the purpose and the intended use of the equipment be spelled out very clearly. You see here, importance of contracts. Take control through preparation of first drafts. Now, again, if you've got General Electric that is buying a piece of equipment from you, even if it's for $1 million or more, they're probably going to try to insist on using their purchase order with you. And we'll get to that here in a minute. But those of you that have plans and again are committed to doing business long-term in the United States, my recommendation is that you have sales contracts, and sales contracts that are enforceable in the United States. This is something that has been an evolution in our law firm's practice over the years. Traditionally, in the olden days, I always recommended that one insist on Dutch law applying when our Dutch clients were doing business in the United States, and that all disputes be resolved in The Hague or Amsterdam, Rotterdam, maybe not Nieuwegein. But in any event, however, over the years, we've kind of taken a different view. I like to include in contracts the drafts of contracts, sales contracts, language indicating Dutch law will govern the terms of the agreement, but be prepared in the negotiations to let Dutch law go and allow US law to apply. And here's why. It's long-term. Where will, in all likelihood, any dispute between you and your customer take place? It's in all likelihood going to take place in the United States. Now, if it's with your customer, Maybe you can force them to come to the Netherlands. But even if you win in the Netherlands, if you win a judgment against your customer, you're still, for example, for payment of the balance of the purchase price, you're still going to end up having to probably go to the United States to enforce the terms of the judgment. And as a result, our view is that even if Dutch law were to be agreed to govern the terms of the relationship, it's very important that the contract be enforceable even under U.S. law. And business laws in the United States are quite similar to the laws in Europe and in the Netherlands, but there are some significant differences. And your problem with that is that those differences, if they have anything to do with your dispute, will make enforcing your judgment that you might get in a Dutch court very difficult in the United States without starting over an entirely new lawsuit in the US, which means that the whole idea of having Dutch law apply is lost. So in any event, your contracts, your sales contracts, or contracts with distributors, agents, licensees, etc., should be prepared by your lawyer, and in our view, your American lawyer, so that the contract is enforceable in the US. Again, this comes back to the original question: are you committed to doing business in the United States, or is this a one-off opportunity that you just want to take advantage of? In that case, it's maybe not so important to have a US adapted sales contract. What we're talking about is somewhere around $3,000 to prepare a distribution agreement, rep agreement, that may be a sales contract. It depends, of course, on the specifications in the contract, etc. It might be a little bit more than that, but we're generally not talking about a lot of money to put something together. But to me, the most important thing in the contract preparation is to take control of the negotiations by having your American lawyer prepare the first draft of the contract. What often happens is that our clients send us the contracts that they use internationally, and then we adapt that to US legal standards. And that can cost less than $3,000, but often enough, we recommend to our clients that we start from scratch and use American documentation, but particularly when it comes to intellectual property rights, insurance, product liability, payment terms, security interests, etc., etc. So please, let's read together. Those that operate without written agreements with their U.S. business partners invite conflict. If you do business with a distributor in the US, we're just getting started, okay? We don't really know our American partner very well. We're going to let them start selling our equipment in the US, okay? I know some of you people ought to be listening to this one. We're going to let them get started, but we don't want to have a written agreement with them because we really don't know them very well yet, and so let's just see what happens. Well, that may work. It may very well work. I'm not here to say that that's really stupid, but it may not be prudent. And here's why. Well, you have a contract, but it's an oral contract. And oral contracts mean that you have an understanding of your contract with your American partner, and your American partner has an interpretation of the relationship that you have in your verbal contract. And often enough, those terms differ. And as a result, it invites conflict in the event that you decide to terminate the relationship. Now, I will say this. If you do have distributors in the United States, they are generally not very well protected. Please understand, and this is going to apply to most of the issues that we're talking about today, and that is issues relating to distribution law, product liability, covenants not to compete, confidentiality, applicable law. All of these issues are resolved state by state, and we've got 50 of them in the United States. So you can't just say that in the United States, distributors are not protected when there's an oral agreement. No, but most states do not protect local distributors that do not have the benefit of a written agreement. Now you might say, well, great, then that's how we should operate. Well, but wait a minute, how many emails have you sent back and forth that sort of could be glued together in order to make a contract? So this whole thing gets really messy. And why have it be messy when you can have a contract that spells out what your relationship is? Well, again, Tom, we don't know whether we want to do business with these people long term. And as a result, we don't really want to have anything in writing. Well, then don't do business with them. You know, at least our view. I mean, I'm a lawyer, for goodness sakes. My job is to protect you. And as a result, to me, it's really important to have something in writing with your partners. Now, you could send an email saying, "Dear Joe, we're excited about potentially entering into a relationship with you. However, neither one of us is committed long term." Obviously, if your American partner receives that from you, they're going to go, well, gee whiz, there's no point in me spending any time trying to develop a business if my Dutch partner can pull the rug out from me and go and do business with somebody else from one day to the next. Now, others might say, well, that's fine. I'm going to show you that I'm a great partner so that we can negotiate a deal. There's another option, and that is to enter into a letter of intent. We have a small Swedish client that has decided that that's what they want to do, but be careful with letters of intent. Letters of intent sound like they are non-binding, but they can be binding. It depends on how the language is written in the letter of intent. So if it's just an expression of your intentions with your potential partner, then for goodness sakes, just put that in to the letter of intent. Our intention is to enter into a deal with you, but here are the conditions before we do so. Or we're going to let you sell for us with the intention that we're going to enter into a distribution agreement. But again, that gives you the flexibility to back out if the relationship doesn't evolve. So contracts, any sale of major equipment or has a very specific application or is particularly risky from a product liability standpoint, those should all be subject to sales contracts that spell out very detailed what the parties' obligations are to each other, the specific purpose and application for the equipment, and the division of risk and responsibility. I think many of you are interested in sending people to the United States to install. That contract becomes crucial in protecting you from liability and also helping to get your people into the United States. Yes, from an immigration standpoint, and we'll talk a little bit about that too, having a contract with your customer whereby your customer demands, requires that your people come to the United States, preferably to supervise the installation of the equipment and commissioning and training and would be very valuable, either when seeking a visa, a B1, B2 business visitors visa, or even entering the US on the ESTA. We will get into that. But that kind of language needs to show up somewhere. maybe in your customer's purchase order. But be careful, because your customer's purchase order either is going to have on the reverse side of the purchase order their purchase order terms and conditions, which are going to be draconian, namely bad for you, or they're going to refer to their purchase order terms and conditions on their website. So you're still going to be subject to their purchase order terms and conditions. And so, at least, however, from an immigration standpoint, if you accept your customer's purchase order, that purchase order's got to include very clear language that we can help you in preparing, whereby it is a requirement that you send your people to the United States, your technical people to the United States, to ensure proper installation, commissioning, and all that kind of good stuff. So that's that. Paul, let's go to the next one.
Yeah, Tom. Yeah, let's say before we go to the next slide, shall we just have a look? Well, thank you very much so far for all that information. It's a lot of information to grasp for everybody as well, I think. Shall we have a little look if there are any questions so far?
Sure.
Birgit.
Yeah. There's a question here. What about including a clause to determine a conflict by means of arbitration? I'm not sure where it at what point it was asked.
Oh, this is fine. This is a good time.
It's clear for you.
This is a good time to address that. A great question, and this is one that one could spend a lot of time on, and we're not going to do that. But
maybe I should add, can that still work in a contract based on Dutch law? So if you include a clause to determine a conflict by means of arbitration, can that work in a contract based on Dutch law?
Normally, yes. You know, I'm going to issue my disclaimer. None of this is legal advice, okay? So normally, yes, and that's a good potential solution. Here's my view on this whole thing. If this is a deal where a dispute is possible, and it is in almost any situation, but not for cheap stuff. But here's the deal. We like to put in a dispute resolution clause that starts with senior management of the companies having 30 days to solve it, or 10 days, whatever, to solve the issue. You know, exchanging written documentation as to their positions, etc. Number two, if that doesn't work, then they go to what's called mediation. And mediation is, for those of you that don't know, and when I first heard of mediation, I didn't understand what it was either. But mediation is picking somebody that is not going to decide anything, but is experienced in these types of disputes and negotiations, that tries to help each party see the other party's point of view in order to get them to agree. So first, the senior representatives of the company, then mediation, and then either arbitration or litigation. Now, arbitration sounds better. It does to all of us. However, arbitrators are expensive. They're more expensive than the court. The court doesn't charge anything. You spend a few $100s filing a lawsuit because of the expenses of the court. And then after that, the court doesn't cost anything. An arbitrator, a good arbitrator in the United States these days, is charging around $1,000 an hour. Just so you know, our firm charges $435 an hour for my time. It's a lot of money, but it ain't nothing like an arbitrator. So, and not because arbitrators are particularly fabulous lawyers or otherwise, but they're mostly in bigger cities, and big city lawyers charge a lot of money. And we're in a big city too, but we only work with small to medium-sized companies, and our clients can't afford the big firm fees. And that's one of the reasons why I think Metaalunie has liked working with us over the years. But arbitrators are expensive. Number two, they have their own rules of evidence. And what I mean by evidence means in US lawsuits, the parties devote enormous amounts of time and effort in what's called evidence, and it's called discovery, namely discovering information from the other side to help strengthen our case. In Europe, it doesn't work that way. Essentially, you file a lawsuit and you give the judge your best evidence, and then the defendant provides the court with their best evidence, and then the court decides. Not so in the United States. In the United States, in a lawsuit, I filed my lawsuit, I give the court evidence and the other side some evidence, then the other side gives their answer and their defense. They start asking us questions, and we start asking them questions. We ask them to admit certain facts. They ask us to admit certain facts. We send questions called interrogatories to the other side. They have to answer them. They send interrogatories to us, questions that they want answers to about what actually took place and quality control and who did this and blah, 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 and all those kinds of things that are important for them to gain information to better their case. Then there are depositions, and depositions are where the lawyer for one side asks witnesses of the other side questions in front of somebody that is certified by the court, and that person takes down every word that is said during the deposition, and that gets admitted into evidence in the case. I hope you're getting an idea of how crazy, complicated, and expensive lawsuits in the United States can be. Getting back to the arbitration thing, the arbitrator decides for herself, what evidence am I going to accept? We're not gonna have depositions. You just send me what you got and you send me what you got, and then I'm gonna make my decision. Well, that may be simple, but it may not serve the party's interests, one of the party's interests. You follow me? That we need information from the other side. So that's the second thing. The third thing is that for an arbitration to be of value, you can't appeal it. Well, in a lawsuit, if you lose the lawsuit, you can appeal a lawsuit. Arbitration, the whole idea is that once the arbitrators made their decision, we're finished. You cannot appeal it. And maybe that sounds good, and it does in a way. But so whether arbitration is really cheaper, faster, and more effective, I don't know. It's really a question of taste. Some lawyers prefer arbitration, others don't. Some have had bad experiences with arbitration, so they insist on litigation. Others have had the opposite happen. But I like the idea of the contract requiring that the parties try to resolve their dispute by exchanging written position papers, if you will, and then going to mediation, and then either arbitration or litigation. And that arbitration and litigation can take place in the Netherlands or in the United States or in a neutral country. But the neutral country thing is, I think it's a bit of a thing of the past for reasons I'm not really sure, but I see that very rarely in contracts anymore. Very rarely. Usually one party agrees ultimately to the other. And as I mentioned earlier, the contracts often should start with Dutch law, but you should be prepared to give up Dutch law because the American is going to say, we don't know a thing about Dutch law. We are not going to do business with you under Dutch law. But hey, the purchase price, negotiations, covenants not to compete, et cetera, intellectual property rights protection, exclusivity, all these different kinds of things. You can say, well, we'll let you have Delaware law applied to our contract, but then we need all these other things. And you'll be surprised. Americans are willing, because their American lawyers are scared of Dutch law because they don't know anything about the Netherlands. They don't even know where it's located. Sorry. But so,
So-
but you know where it's located. That's good. So there are a lot of things that can be done here. As you can tell, this is all we do for a living, is these kinds of deals. So you can exploit the hour that I'm offering to you to get answers to some of these types of questions. Any other question?
No, I don't think there are any questions at the moment, unless Birgit. Otherwise, I think that we have to move on to the next subject. I'm looking at the time a little. We are doing all right, Tom, for time, but I think we do have to move on to the next slide. Shall I?
Yep. Yeah. Absolutely.
Let's have a look at the sales terms and limited warranties.
Yes. Okay. Metaalunie has really good sales terms and conditions. But some of the conditions, two that I remember off the top of my head, relating to retention of title and product liability and the warranty, that whole area, are not quite adapted to US standards. And I don't think that Metaalunie ever had the intention of their sales terms and conditions to apply for sales to the United States. But it's important for you to understand that some of these provisions will not be enforceable in the United States. And because they're not enforceable in the United States, you risk that in a dispute with a customer in the United States, even if you've been able to get them to accept the Metaalunie sales terms and conditions, you will be in for a fight in getting them to be enforceable. Why? Because some of the provisions are not enforceable in the United States, and your customer in the United States is going to use that to tie things up in court, saying, Judge, you can't enforce this particular provision of the sales terms and conditions because these others aren't even enforceable. The whole thing should be thrown out. Now, you and I know that should be a losing argument. That's not the point. These things take months, if not years, to resolve that specific issue. Yeah, tens of thousands of dollars in legal fees. The key is then to get the sales terms right. Sure, the Metaalunie terms can largely be applied to the US, but this area particularly, and I want you to, this is a really important one for you selling to the United States on credit. First of all, selling on credit to the US, well, there's a risk. Letters of credit, we generally don't like letters of credit in the United States. We still don't quite understand them. Bank guarantees, they're costly. Customers don't want to use that. So to me, my advice to you that are selling to first-time customers in the United States that you don't know anything about, and you're going to ask me, well, Tom, how do we find out about them, these companies and their credit worthiness? There's Dun & Bradstreet, but Dun & Bradstreet gets their information from the target company. So, how valid is that going to be? How credible is that information going to be? Tax returns are not public in the United States. As you know, we have an ex-president, and I don't want to go there, that refused forever to disclose his tax returns. I don't know why. Maybe you know why. Can you tell me why? All right, thank you. I think I made my political comment. So when you sell to Americans, if you're selling on credit, get half up front before you start working on the order. Get another 30% when it's ready to ship. Get another 10% when it arrives in the port or something like that. Maybe that's already too complicated. Get 50 up front, 40 when you ship, and 10% on commissioning. And then, of course, the language relating to acceptance is crucial. And too often we see and this is another one that's really important. We're going to get back to the credit business here in a minute. But acceptance, if you leave it to the customer to say, I accept, wait a minute. What if they don't say, I accept? Well, you'll never get that 10%. So you want to have objective criteria, the performance criteria of the equipment. And as long as your equipment lives up to those objective criteria, the customer's got to pay. So that's a really important one, the acceptance criteria, especially for expensive equipment. Now, so let's say that you, some of you may have already sold equipment and you sold it on credit, say 50% up front, and the customer still owes you 30% or whatever it is, 20% of the purchase price. And in the Metaalunie terms and conditions, and most European terms and conditions, there's a clause that says that you retain title, ownership. You retain ownership of the equipment until the last euro or dollar is paid. That is entirely unenforceable in the United States. It is of zero value. In the United States, according to what's called the Uniform Commercial Code, as soon as you deliver the equipment to the buyer, and it might be your factory door, it might be Ex Works, as soon as you deliver that equipment or that product to your customer, the customer owns it. Period. Period. They own it. Some people think, we will lease the equipment to our American customer, and then the last payment will transfer title. No, that used to work, and then the court system figured out that that was actually a credit sale, right? Because that's what it is. It's not a lease, it's a credit sale. So then what do? Well, you get paid up front to the extent that you can get paid up front because you're taking a substantial risk, because once the product is delivered, your customer owns it. Well, all right, then what do? Well, in the United States, we have what's called, and it's also pursuant to this law called the Uniform Commercial Code that all states in the United States have adopted. There is such a thing as a form that can be filed with the public authorities in the state, and county where the equipment is located, that puts the public on notice of the fact that you have a security interest in the equipment. You don't own it, but you have a security interest. And if that form is properly prepared, and you have a right to file that form, and you have to get that right to file the form from your customer. If that form is properly prepared and filed, then you will have what's called a secured position in terms of your equipment. And if it's a distributor, you want to put in there that you have a security interest in the products that are in the possession of the distributor and any accounts receivable from customers of the distributor, and even the proceeds, the cash that they receive from customers. So that if your customer goes bankrupt, for example, you are a senior secured creditor rather than an unsecured creditor. And I think it's the same in Europe as it is in the US. And also, if you've put in good language in your terms and conditions, and more particularly in the sales contract, you would have a right to go in and take back the equipment. Well, some of you are sitting there going, yeah, but we'll never do that because we make our equipment to order. And number two, it's installed on our customer site, and unhooking it and removing it. No, we're never going to do that. Well, to me, that argues in favor of getting more money up front getting more of the payment secured early on. So adapt sales terms to U.S. legal standards. Why? We're just talking about why that's really important to do. It's important to do when it comes to the warranty law, and that's the last one here, U.S. warranty law. Never guarantee anything. I think we already talked about that. Only grant limited warranties. And that is because U.S. warranty law is very demanding. If we guarantee that the equipment will work for 5 years and and do this many repetitions and produce this many products, it's a guarantee. If they leave the machine outdoors and the snow and water gets in there and damages it, well, that's your problem. You guaranteed it. So just don't use the term guarantee. Use warranty and limited warranty. Why? Because as soon as I see the words limited warranty, it means, oh, I better read on so that I understand what the limits are of the warranty. You and I know that the whole purpose of the warranty is to protect the seller, not the buyer. So the whole idea is to put in limitations in the warranty so that you are not held responsible. These limited warranties also are very important when it comes to limiting your liability risk, when it comes to product liability and those types of things. So some of you are selling equipment to very big companies in the United States, and many of our clients sell products to big customers. And the big customers insist on using their purchase orders. And sometimes it's a purchase order for equipment, but our client is providing software, which it's really silly because the purchase order just doesn't apply to software. But in any event, what happens, and this is really important as well, is that clients of ours, being small to medium sized, they get an order, the biggest order they've had for a long time, perhaps ever, from an American customer, and they break out the champagne and they order new equipment and they start building a side building, and then the American customer cancels the order. You can't cancel the order. We got this purchase order. Oh, you didn't read the fine print. And the fine print says we can cancel the order at any time. Yeah, but you got to pay us for all of our expenses. Yeah, you have to prove to us the variable costs associated with our order that you incurred in filling our order. And buying a new piece of equipment, that's not a variable cost. That's your problem. Yeah, but we spent $500,000 on this new equipment.
Tom.
You bet.
Tom, can I interrupt? I think that I have to do a little bit of time management. We have 2 more subjects to go on. And we have like 20 minutes, 25 minutes to deal with that. Do you think you can make that?
I'm going to try.
Great.
Okay. So it's
great.
now, let's move along then to, I guess it's product liability.
Let's do that. And just a small question for Birgit. Are there any questions asked up till now?
No, at the moment, not. Not at the moment, sorry.
I would say even better.
I am getting a question now. Maybe you can answer this shortly, if it is possible. Could Tom explain something about the required certificates if you export a machine, like a UL certificate? Is that a question you can give a short answer to, or is it something that we could maybe deal with
this would probably be a good subject to take up on a face-to-face Zoom or Teams call later this week or next week. But on the question of UL, UL approval is not illegal. That's Underwriters Laboratories, and they issue certificates for any product that is run by electricity. They'll do it for others as well, but they're known for that particular industry. But most equipment runs on electricity. So UL approval is a terrific marketing tool. It's also terrific in defending a claim concerning product defects because you will have gotten UL approval. However, it is not a legal requirement. It may be a contractual requirement of your customer that says you have to have your equipment UL approved before you ship it to us. Well, okay, well then we have to do that. But it is not a legal requirement under the law in the United States. I think CE certification is something that is required. Now, this is a good segue into the whole issue of product liability. The service that we provide is called product. Paul?
That's okay. You're moving on to the subject. Is that correct?
Yes, yeah, I am.
Great.
Yes,
Thank you very much, Tom. That's great.
Yeah.
Thank you.
Product liability preventive management. Why? Well, because if you're sued for product liability, you're in trouble. Now, let us be clear. Don't do business in the United States without having insurance. You've got to have product liability insurance. Indeed, if you don't have product liability that covers you in the United States and you do business in the United States and you get sued for product liability, it might be viewed as being so irresponsible that it might open up the possibility that the plaintiff, the claimant, might be able to pursue more than just the Dutch company. So don't even think about doing business in the US without having insurance that covers you in the US. Yes, but it's ridiculously expensive. Well, sure, it's ridiculously expensive because because the US is the most litigious country in the world. That's why you're listening to me today. So what do? Well, one thing that you can do, and that is to set up a US company and sell your equipment through the US company. I'm not saying that that's going to protect you in the Netherlands. However, the US company, if it does sells the equipment, it has the contract with the customer. If the product doesn't or equipment doesn't work, it's a contract failure. You breached the contract. And it's your American company that has the contract problem. Product liability is much more complicated because you created it, you developed it, you designed it, you made it in the Netherlands, you shipped it to the United States. You can't hide behind a US company. However, your US company can buy insurance. You cannot buy insurance as a Dutch company in the United States. That would have to be done by a US company. And we have set up lots of companies over the years whose sole purpose was to buy insurance. Now, it's not going to be less expensive in the US. Yeah, but we cannot get our insurance carrier to follow us to the United States, Tom. Well, then you tell them, look, if you want to continue to be our insurance company, you're going to cover us in the United States. Otherwise, we're going to take our building insurance, premises, business interruption insurance, employee auto insurance. We're going to take that to somebody else that will offer us product liability insurance for the United States. You have a better chance to negotiate with your insurance carrier in Europe than you would negotiating with an American insurance company. But the reason we talk about product liability preventive management is that, as you see on the second column, have insurance, but it's not enough. So you got to have insurance, but it's not enough. And why is it not enough? Here's the reason why, and this is also a big one, and that is that in a lawsuit in the United States for product liability, if you lose that suit, okay, let's say that you lose the suit, and the suit was for $3 million. You lost the suit, but you don't lose $3 million. What do you mean we lost the lawsuit? Well, what I mean is that a week or 2 or 3 or 4 weeks later, the plaintiff's lawyer has to come back into the courtroom to prove up their damages, to show to the court's satisfaction that their client suffered $3 million in damage. Because otherwise, we'd all sue each other for $100 billion, right? If you win the lawsuit, you get $100 billion. No, you have to show that you suffered $100 billion in damage. So that's why lawsuits are sometimes reasonable in the US. So proving $3 million in damage is very difficult to do. So the plaintiff's lawyer's work is not done just by getting a judgment against you. So what happens in American product liability lawsuits, and I know we're short on time here, but this is really important for you to understand, is that if you lose the lawsuit, the damages are broken into what are called consequential damages and punitive damages. Consequential damages are damages that you might be able to recover in the Netherlands. Salary that didn't get paid when I was out injured, medical expenses that might not have been reimbursed, child care while I was out sick, pain and suffering. You know, there are some statutory damages that you can get in the Netherlands for injuries, those kinds of things. Those are consequential damages, and they generally come up to maybe $50,000 or $100,000 in a lawsuit. Let's say that they come up to $200,000 in this lawsuit. Well, but the lawsuit's for $3 million. How do we get $2.8 million? Through punitive damages, through showing to the court satisfaction that the manufacturer behaved recklessly, they disregarded the safety of our client, and as a result, they should be punished for that. Well, why am I talking about this? Because punitive damages are not covered by insurance. Ooh, what? That's right. Consequential damages, they're generally covered by insurance. Punitive damages are not covered by insurance. There's no insurance, not even Lloyd's of London will insure over punitive damages, which means that you've got to take steps now before there are any claims in the future to reduce the risk that anybody ever gets hurt. Because of course, when people get hurt, that's when claims come up. So what does that mean? It means these things on this outline, namely, to be aware of codes and regulations, to do quality testing throughout the process, to have all of your media reviewed to ensure that exposure to liability is limited as much as possible. Namely, some of you are selling equipment to industries where you know that a lot of the people that are going to be using your equipment don't speak or read English. Oh, yeah, that's right. Well, you better get it in Spanish or require that your customer translate it. No, we don't want our customer to translate anything. Well, that's one thing. So what you want to do is you want to adapt your media, namely your website, your brochures and promotional materials, your instructions, your warning labels, your disclaimers, your limited warranty, limitations of liability, indemnification language, all that needs to be adapted to US standards to reduce the risk that anybody gets hurt and to reduce your exposure to liability risk in the event that somebody does get hurt. So the idea here is to take additional steps beyond what you have already done so that in the event that you ever lose a lawsuit, then you can go into court and show, hey, wait a minute, judge, we should not be subject to punitive damages because look at all this work that we did in order to reduce the risk that anybody gets hurt in the United States before we ever had any problems with claims in the US. This is something that we do quite frequently for clients, and we're talking about $2,000, $3,000, $4,000. That's more than you're going to spend the first day. The first day, the first day. that you're ever sued for product liability. So it's, and what a lot of our clients do is they say, geez, you know, this is pretty good. We appreciated that risk, but we understand that our customers may not appreciate that risk with our equipment. We're going to put that into our documentation. So the work that we do actually sometimes leads to clients using that in other contexts. Be happy to have a conversation with you about that specific subject, but we have 15 minutes left. Any questions directly about product liability? No. Then
yeah, one question. Is it common that US clients sue Dutch manufacturers for product liability in the Netherlands? Punitive damages are not enforceable in the Netherlands.
I think that's a great question, and I think you answered it. Because of the fact that as soon as they think about these suing the manufacturer in the Netherlands, they'll realize, oh, I can't get punitive damages, and damages themselves are quite limited, so they would then abandon that idea. Now, it's not the client that in all likelihood that would sue. It would be a third party, namely an employee that is using the equipment, somebody that has come in to service the equipment, somebody that happens, an invitee, namely a customer of theirs, comes into their shop and they are somehow injured by your equipment. And those people, they're going to sue you in the United States. Why? Because your equipment's here. I got injured here in the United States. They don't have any obligations to you. They don't have a contract with you. Your customer has a contract with you. Now, your customer, your client, might sue you as well, particularly if you're not defending the lawsuit. They would probably also be sued because they're the employer, or they are the person that the party that invited someone to come onto their premises that ultimately got injured. So they would likely be defending a lawsuit as well as you. But it's unlikely that you would be sued in the Netherlands.
Okay.
Immigration.
Yep.
All right. Well, thank you, Thomas. Great name, by the way. I've been doing this for, all right, closing in on 40 years. But as you can tell, I really like this, and it's a lot of fun. It's a decent way to make a living. And the immigration laws haven't changed in 40 years. It's crazy. The immigration laws were written 50, 60 years ago or more. I don't even know. But it's the same basic laws ever since I started working as a lawyer. They were written long ago, to give you just a little bit of a background, to facilitate massive companies bringing people in from overseas. Why? Well, because when I was a kid, foreign companies didn't do business in the United States. They did business at home. You know, we're not going to get into that. Just trust me on that. So taking that into account, the Immigration Service still behaves as though the laws were written for big companies, but now they're small companies. As I mentioned, all our clients are small to medium size. They're just starting up activities in the United States. They've opened up a company. They may have an employee, but they need to send some people over from the Netherlands to manage the activities in the US. It's a mountain. The laws have not changed. The interpretation and enforcement of the laws has changed dramatically over the last 20 years in particular, and they keep turning the screws slowly but surely. And it's not whether it's Biden or Trump or Obama or anybody else. It's simply that there has been so much fraud against the U.S. government, the Immigration Service, that they've said, hey, look, oh, I'm coming to start up my business here in the U.S. Give me a visa. No, not anymore. So it makes it quite a challenge to get visas. So for those of you that do have plans long-term to set up U.S. operations and send people to the U.S., get on the horn with me. We need to talk about your planning that needs to be put in place. Understand that it is not the visa candidate that seeks a visa to live and work in the United States, and it's not the Dutch employer that can serve as an effective sponsor of a visa application. Well, then who is going to sponsor the visa? It's your U.S. subsidiary. It's the company that you would set up in the US, of course, would be happy to help you do that. But that's the company that the Immigration Service is going to look at the closest to determine whether they're going to give you and your employee a visa to live and work in the US. And over the years, it's become more and more, the Immigration Service has become more and more demanding as to what needs to be shown in order to be able to get a visa. For example, some of you that are selling equipment to the US that have plans to set up operations in the US and send people to the US, set up your US company today, and we can do that very quickly, and it'll cost you around $2,500. We're not talking about a lot of money here for those of you that have a long-term perspective. So you set up the US company and sell the equipment through the US company. Why? Because then we get to start showing that the US company is in business and is making sales. That's going to make the immigration people happy because they see that the US company is making money. Sure, we can approve a visa for a company that's making money. A lot easier than we can approve a visa for a company that just got set up that doesn't have a bank account yet. By the way, concerning bank accounts, if you use us to set up a bank account, if you use us to set up a company in the United States, we can open up a bank account within a matter of days without you being present in the United States. Try that with another law firm. I've worked for years to develop a relationship with a bank here in Chicago. It's just one bank, but they trust me and they trust that our clients are not in the money laundering business. And so they're happy to open up bank accounts within a matter of days. There's some aspects of what you're up to in the United States that we can really be quite valuable for. Now, let's get to the toughest issue, and I wish we had run out of time so I couldn't address this, because I know some of you are sitting there going, yeah, but we don't want to send people to live and work. We want to send people over there to install our equipment. The law does not provide for an easy way to come to the United States to install equipment. And it's ridiculous, and it shows the political ineptitude of the Congress. And of course, it's showing more and more ineptitude every day. Essentially, for those that are coming to install equipment, there is no visa. And it's ridiculous. However, thousands upon thousands of people enter the US every day to install equipment. How do they do that? I'm visiting a customer. Here's your number one rule. And we need to turn off the recording. Number one thing, if you have equipment and tools and things like that that you need in order to install equipment, send them ahead of time. Do not have them in your baggage. That's a winner. That's a real valuable one. Number two, as I discussed earlier, the contract with your customer has got to, in bold-faced language with neon lights, scream in several places, preferably in the contract, the requirement and why it's required. Not just the requirement, but why do we need to have these Dutch technical people or technicians come to the United States? you know, with nice flowery language. We don't have this technology. We need the Java. You know, the software program is such that all this kind of good stuff needs to be in the contract. So, and a copy of that contract needs to be in the attaché case of, or the bag of the individual coming to the United States. Never volunteer anything to the Immigration Service. You know, again, we need to have a conversation so that I remember all of the things that are important when it comes to entering the United States, if your intention is to install. Now, if it is such that we cannot take any risks here, Tom, this is a $5 million piece of equipment. If this works, there are 5 other installations in the United States where they're going to want this equipment. This is big stuff. We cannot take any risks. Well, then we should have a conversation about seeking a B1, B2 business visitor visa for the individual. The ESTA allows you to come to the United States for up to 3 months at a time. It allows you to attend meetings, go to conferences, make sales calls for your foreign employer, etc., but it does not allow you to provide meaningful services on U.S. soil. And that's where we get into the dang installation, commissioning, training business. People who give seminars and presentations for money, they technically they're not allowed to enter the United States without having a work visa. Well, there's no work visa for them. Now, the B1, B2 visa, I know we only have 3 minutes left, Paul, but the B1, B2 visa is one that is good for up to 6 months, and it allows people to come in to supervise the installation. So ideally, the contract with the customer, and hopefully it reflects what actually is the truth, should state that your technical people are needed in order to supervise the installation of the equipment and commissioning and all that kind of stuff, rather than doing all of the work on the equipment themselves. So this requires individual attention to your particular immigration challenge to get your people into the United States. But there are some tricks of the trade. I'll be happy to share those with you and discuss whether we need to, whether a visa is actually needed. So in conclusion, skip to the last page, secure legal help before you do business in the United States. Those of you that already have contracts, one of the things that I invite you to do is to consider sending the contract to us, and I would then provide you with a quote for what it would cost for us to go through the contract and provide comments and recommendations. That's often the way we start working with clients is, and we will never charge you a penny until you sign our engagement letter and send us a small retainer. So, you know, use me for all I'm worth until such time as I say, okay, enough's enough. Now you got to sign our engagement letter so that we can start charging you. But, you know, I'm happy to spend that hour with you, holding your hand and hopefully providing some more meaningful, direct guidance to your specific situation. I really appreciate the opportunity to have been on here today, Paul and Birgit. Thanks so much for inviting me and for organizing this. I hope people got some value out of it, and look forward to seeing you this spring.
Thank you.
Thank you.
Thank you, Tom. That was great. I mean, it's a lot of information, and it's probably also a little bit tough to digest for everybody because it's so much. But it was clear, and thank you again for that. That was very, very good. Now, what I will do is I will try to see if I can stop the presentation so we can see you a little bit bigger like that. That's very good. Let's have a look if there are any sort of last questions. Birgit.
Not at the moment, but maybe in a second.
Okay, well, let's do it this way. I mean, if there are not any questions, I will actually now stop the recording, but it doesn't mean that everybody needs to leave, because I have also something to ask you. If you would like to have a private chat, a private discussion with Tom, you can leave your name, and we'll contact you. But let's do that after the recording. So I'll stop recording, and I thank Tom. I thank you very much for this good presentation, and I'd like to thank also all the participants for listening, for being here. Obviously, if there are any questions, you've given your address and contact details, Tom. It is on the last sheet. Everybody's got them as well, because everybody's got the presentation. And if there are any questions, please also ask them to Metaalunie. Birgit, maybe you could maybe just enlarge a little bit on that. How does that work?
If people have questions, well, you can just send your question to international@metaalunie.nl of internationaal@metaalunie.nl. Werken allebei. Of je kunt ons even bellen. En dan wordt de vraag opgepakt door mij, of wel in samenwerking met mijn collega's van bedrijfsjuridisch ledenadvies, die ook mee kunnen kijken, mee kunnen denken over overeenkomsten met partijen of klanten of distributeurs, et cetera. Vanuit het Nederlands recht, moet ik er wel bij zeggen. En waar de kennis verder nodig is, verwijzen wij natuurlijk heel graag naar Tom